And you should be able to hear me now too.
All right, everyone, there are some people trickling in, but we're going to go ahead and get started today. Thank you for attending today's CLE program entitled Moore versus Harper, the Independent State Legislature Theory and the 12th Amendment to the Constitution, which is being presented in association with Keep Our Republic. At about the 1 hour mark, so at around 11 a.m., a poll question is going to pop up on your screen that you will need to answer to receive CLE credit. There will also be a poll at the end of the program. Please pay attention and make sure that you answer these questions. During the program, please utilize the chat function to ask any questions. I'm going to turn my spotlight over now to Professor Huhn. And Professor Huhn, would you kindly get us started today?
Very happy to, and thank you so much, Sam, for all your hard work and getting this wonderful program ready for everybody. We're going to be talking today about a very important development in the law, in constitutional law, and having to do with our selection of Congress and selection of President of the United States. Just a second while I share my screen. An analysis of the independent state legislature theory. We have three very distinguished presenters today. Our commenters will be former Governor Thomas Corbett and Chief Justice Emeritus Thomas Saylor of the Pennsylvania Supreme Court. Both of them engaged in private practice of law, but they embraced careers in public service and rose to the highest positions of state government. Thomas Corbett received his undergraduate degree from Lebanon Valley College, and he earned his law degree from St. Mary's University School of Law. Tom Corbett has a long and distinguished career of public service in the Commonwealth of Pennsylvania in both appointed and elected positions, as a public school teacher, as a member of the Army National Guard, where he rose from private to the rank of captain, as an assistant district attorney, assistant U.S. attorney, town commissioner, U.S. attorney, chairman of the Pennsylvania Commission on Crime and Delinquency, state attorney general, and ultimately governor of the Keystone State. We're very proud that Governor Corbett now serves as a distinguished executive in residence at the Thomas R. Kline School of Law of Duquesne University. Thomas Saylor is an honors graduate of the University of Virginia and received his law degree from Columbia University and a Master of Laws from the University of Virginia. Thomas Saylor worked as an assistant district attorney, director of the State Bureau of Consumer Protection, deputy attorney general, Pennsylvania Superior Court, and finally on the Pennsylvania Supreme Court, where he served for 24 years. He became Chief Justice in 2015 and remained chief until 2021. During his tenure on the court, he authored over 400 main opinions and 6 law review articles. Chief Justice Emeritus Saylor is the inaugural judicial scholar in residence of the Thomas R. Kline Center for Judicial Education. This is particularly appropriate because when he became Chief Justice, he persuaded the court to adopt a system of mandatory continuing judicial education for trial and appellate judges. The law school and its students are so fortunate that these two leaders and public servants teach our students about the profound responsibilities of lawyers, judges, prosecutors, and other officials in their duties to the public. Our featured speaker today is Attorney Jonathan Weiner. Mr. Weiner earned his undergraduate degree from Yale University in 1976 and his JD from NYU School of Law in 1981. Jonathan Weiner served as U.S. Special Envoy for Libya, Deputy Assistant Secretary of State for International Law Enforcement, and counsel to U.S. Senator John Kerry, expert on U.S. Middle East policy, counterterrorism, international money laundering, illicit networks, corruption, and U.S.-Russia issues. In 1999, he received the State Department's second highest award for having created the capacity of the department and the U.S. government to deal with international crime and criminal justice as important foreign policy functions. The award stated that the scope and significance of his achievements are virtually unprecedented for any single official. In 2016, Weiner received the highest departmental award granted by the Secretary of State for extraordinary service to the U.S. government. Mr. Weiner has written and advised on election law generally and on the state independent legislature doctrine. I turn the program over. Oh, one more thing. Here are the constitutional provisions that are at stake here. Article 1, Section 4, Clause 1, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the state legislature thereof. And in Article 2, Section 1, Clause 2, each state shall appoint in such manner as the legislature thereof may direct the electors for president. Mr. Weiner will be speaking about the theory that grows out of that language in the Constitution. And I turn the program over to Jonathan Weiner. Jonathan, you are muted.
Thank you very much, Professor. It's a tremendous honor for me to be here with all of you and with this extraordinarily distinguished panel. As a non-Pennsylvanian in particular, I feel a particular obligation to make sure that what I'm doing is providing as best I can a framework for discussion rather than advocating any particular point of view. So what I'm essentially going to do is to go through as much law as any of us can tolerate very efficiently so that we can then talk about it and try and get a shared understanding of what's going on. So we're going to basically provide the framework for thinking about the Supreme Court's coming review in Moore versus Harper of elements of the independent state legislature theory in the context of legislative redistricting. And we're then going to expand it outward to what its implications might be for the 2024 presidential elections in light of the relationship of the Electoral Count Act, the 12th Amendment of the Constitution, the provisions of the Constitution that Professor Huhn just went through, and the Pennsylvania Constitution, which also is going to play an important role. And Pennsylvania truly is a keystone here for the future of how the country is going to look at all of this. So let's go into the presentation. So to go back to text, which is tremendously important here, Article 2 of the Constitution grants Congress the authority to choose the time at a national level, basis when presidential electors are chosen, the date on which they vote, and it grants state legislatures authority over the manner in which they're appointed. So Congress gets to decide what's election day and what's the day that the electors who are selected under the election as part of the Electoral College have to be chosen and ballot, that is vote, and send those votes up to Washington. The Constitution requires winning candidates to receive electoral votes from a majority of the entire number of electors appointed. And all 50 states have enacted laws saying that the popular vote decides. Now, they didn't have to do that because the Constitution says it's up to the state legislatures to decide as to how they're going to be chosen. They could be chosen in theory by the legislature, by the governor, by the Secretary of State, by some other mechanism, but every state says, no, the people are going to decide. Now, the 12th Amendment sets out the process for presidential electors. They meet in their states, they vote by ballot, they make their lists. The winners are certified. The certification is transmitted to Washington. The President of the Senate, as happened in 2020, it was Vice President Pence, opens the certificates and the votes then get counted. Who does the counting? Not specified. Does that person or body have any discretion over what to count? These questions have actually vexed Congress for 2 centuries and have come up from time to time with different degrees of controversy, more the last time around than ever before, and potentially even more next time around. The independent state legislature theory, which has really only been discussed in connection with a few elections before, most recently in Bush v. Gore in 2000, prior to 2020, contends that under the Constitution, the state legislatures have the sole ultimate right to decide who's certified as presidential electors from their state. And because of what's in Article 2, Section 1, Clause 2 of the U.S. Constitution, the idea here is U.S. Constitution doesn't talk about the Pennsylvania Constitution or any state constitution, doesn't talk about federal law, doesn't talk about state law. It says each state shall appoint in such manner as the legislature may direct. In such manner as the legislature may direct. Maybe I'm going to say it a third time. I am. In such manner as the legislature shall direct a number of electors equal to the whole to which the state may be entitled.
So Jonathan, can I interrupt a minute?
Go.
What a quick thought process is then, could a legislature say, from now on, we are going to make that decision by the winner of each congressional district?
Absolutely.
So you could have, we have 19, you could have 10-9 of electors coming out of Pennsylvania being reported to Washington.
Yes, but what's never been determined is whether they can do that after an election as opposed to before the election. And that anticipates some of the discussion we may have later on the Electoral Count Reform Act, which is supported by both Senator Mitch McConnell, Minority Leader, and Senator Chuck Schumer, Majority Leader, precisely because it answers this question. But this question, as true in Nebraska and Maine today, if a state decides ahead of the vote to do it by district rather than by state, absolutely the case of McPherson v. Blacker going back to the late 19th century makes this clear, and no one contests that. So the question becomes, how should the word manner be interpreted when it comes to choosing presidential electors? And this gets into the Electoral Count Act that we've talked about and the constitutional authority reserved for the legislators. So the federal law on the Electoral Count Act has got a calendar for states to submit electoral votes, a process to have them recognized by Congress. And the idea was to bring certainty for everybody. So there wouldn't be a lot of arguments about most things. There'd be a roadmap that everyone could accept pretty much to increase legitimacy and certainty for everybody. And so the basic idea is we're going to accept and as the Congress, what the state says the winners are, the winning electoral votes, when the state has laws providing for the final determination concerning the appointment of the electors, they all do. The laws have been enacted prior to election day, and there's a final determination at least 6 days before they're supposed to cast their votes and then send their votes to Washington. That's the law as it is right now. The question that's never been answered, has never been brought up and taken up by the Supreme Court in this way, is whether that provision is constitutional, because it is a federal law about electors, which purports to provide binding guidance about how we're going to treat state legislators and the decisions of state legislatures. More to come. Meanwhile, another provision of the Electoral Count Act requires the governor to send the archivist a certificate identifying the state's electors and popular vote canvass as soon as practicable after the electors are appointed. But under the independent state legislature theory, if the state legislature disagrees, you could have potentially competing certificates. State legislature says, well, we know that the governor has sent in this certificate under the Electoral Count Act, but we think the election went bad and we're going to appoint a different set. And this is the situation that we actually were facing last time around, which didn't quite mature, but came close to it. When quietly, but systematically, the Trump-Pence campaign in 7 states were organized to create separate slates, in some cases, not even of the electors that had been on the ballot. as having won rather than Biden-Harris. And none of the state legislatures actually acted to make these certifications, though they got a lot of pressure in December of 2020 to do this. So there was no lawful basis, as near as anybody can tell, for these self-declared electors to submit their names. You can't point to a provision of law that allows somebody to do this when the legislatures haven't acted. And so the Justice Department is investigating what would have been called fake electors in connection with the insurrection, because they see the whole thing as united. And this is what the special committee to investigate January 6th has also been looking at. And it may well be the subject of the next hearing, which is coming up, their final hearing next week. Now, in Moore versus Harper, remember that's the title of the seminar we're giving. The U.S. Supreme Court has decided to address this related issue under ISL theory, which is the state legislature's power versus judicial authority over congressional redistricting. And this becomes absolutely acute in Pennsylvania, which we're going to get to in a minute, because the Pennsylvania Constitution is so explicit about right to vote. And Moore v. Harper is going to decide whether the North Carolina Supreme Court had the power to strike down a congressional map for violating the North Carolina Constitution, which the North Carolina Supreme Court said this is a constitutionally legal gerrymander, not acceptable. And the North Carolina legislators who wanted to see that map accepted argue that based on the elections clause of the Constitution, state court had no right to do this. We decide what the maps are. You don't get to decide because the Constitution grants us this. So in essence, this case, which the Supreme Court has accepted, will determine under what conditions state rights have the right to reject legislative maps. This is gerrymandered. This isn't fair. This isn't constitutional. This isn't equal protection under state law. Doesn't meet the requirements of state law. Or alternatively, whether the state legislatures really can say, hey, U.S. Constitution gives us the right to decide on the manner and the place and the time and the means of drawing constitutional maps, and state courts have no authority here. That's really the choice, and we don't know what the Supreme Court's going to say about that or how far it's going to go, because there are various nuances to it as to how far they could decide what it all means. So let's go back and look at what the statute says, and then I'm going to turn to you, Governor Corbett.
Okay.
I just want us to all look at the language, so it's not my characterization, but we're looking at the words. The time, places, and manner of holding elections for senators and representatives shall be prescribed by the legislature, but Congress can make or alter such regulations. So what does regulation of time, place, and manner mean, given when Congress hasn't acted? This does not address the role of state courts in determining what the state legislatures can and can't do under the state's constitutional and legislative framework. Governor Corbett.
So, and it does not address the issue of who draws the boundaries.
It does not.
So they're connecting two things that really are two different parallel planes, in my opinion.
Yeah, I think they are, but I don't know whether they're going to come out. But what's interesting about this for me, in addition to its impact over redistricting and this question of whether state legislatures exist independent of the state court system, is that this is going to be a two-step, very likely. You interpret this one first, and then you apply principles from this one to the other provisions governing the presidential electors. And we're going to look at that interplay over the course of this seminar.
Well, my
yes,
initial
sir.
reaction to this whole independent state legislature is that somebody seems to be forgetting what we've learned since 4th or 5th grade civics, that we are a country both at the national level and the state level, 3 branches of government that are co-equal. No one is more important than the other. And hopefully the Supreme Court remembers that, in my opinion. Now, keep in mind, I'm a Republican, as is my colleague over on the bench, but I taught this in history in 9th grade. How can there be an independent state legislature? Independent from who? From the governor, from the courts, or from the people? It makes no sense to me personally.
Well, Governor, my views are similar, but I am a Democrat. I came up working for a Democratic senator as his counsel for a decade when I was working on election law issues. And my job here today is, to the best of my ability, to give text and information and not to intrude my opinions. I'm not from Pennsylvania, onto the worthy participants from Pennsylvania here. So I'm confessing what my policy and legal views are, but I'm trying as hard as I can to provide the information impartially. So that's why it's great to have you all participate as commentators, so we can get views out as well as look at text. So the proponents of this theory read the election clause to give state legislatures nearly exclusive authority to regulate federal elections, absolute contrary federal law. That is when Congress explicitly writes a law which clearly governs elections of federal congressmen and senators, but not necessarily electors. So the strongest reading of this would indeed prohibit any other state entity from limiting state legislative power over federal elections in the state. So let's look at what the Republican caucus of the Pennsylvania Senate has said in their brief in this case, which is an amicus brief. It's interesting. They say Pennsylvania's recent jurisprudence helps illustrate the undesirable outcomes that can occur when state court justices, forgive me, Justice Saylor, in reliance on vague provisions in state constitutions, deem invalid and then create or rewrite redistricting and other laws that govern federal elections. The very approach the North Carolina judiciary took in this case. The Pennsylvania Supreme Court, acting to address what it deemed to be violations of Pennsylvania's constitution, has made laws by creating or rewriting redistricting and other laws that govern federal elections. Pennsylvania's experience helps to illustrate the anti-democratic outcomes that can occur when state court justices usurp the authority that the Constitution's clause in the U.S. Constitution bestows on state legislatures. Now, that is a perfect articulation of the strong reading of the independent state legislature theory. How far might the Supreme Court go in accepting Senator Kim Ward's point of view on this? We don't know, but we'll know over the next year, and could have a direct impact on Pennsylvania. Now, interestingly, Pennsylvania until this week had its own ISL case sitting in front of the Supreme Court, Costello v. Carter. And former state Congressman Ryan Costello sought a full merits review to assert that the ISL language constrained the discretion of courts to impose congressional maps in response to a constitutional violation or an impasse in the state legislature. And he was trying to invalidate the Pennsylvania Supreme Court's map, which wound up governing redistricting. Attorneys for the governor said Costello failed to raise his arguments at state court level and lacked legal standing. Supreme Court said, U.S. Supreme Court said, we're not taking up this case. They could have done as a companion to more, but they're decided not to bother. So as of earlier this week, October 3rd, that case is gone. But it's interesting that it arose because it shows how much this is contested right now in Pennsylvania. And that's why I wanted everybody to be aware of it, even though it's now gone. So a new case came up just last month. The Republican National Committee sued the acting Secretary of State of Pennsylvania and various Pennsylvania state election boards, seeking declaratory and injunctive relief to ensure every county adopts identical procedures for casting and counting votes by mail. So we're now getting away from redistricting. We're not talking about presidential elections. We're talking about other elements of manner, time, place. And they argue only the state legislature has the right to decide how defects in a ballot, signature, date, dual envelopes can be cured. Since the governor vetoed the law the state legislature passed covering this issue, the position of the Republican National Committee and the Republican Party of Pennsylvania is ballots with defects cannot be cured. County boards of elections may not adopt cure procedures other than as the General Assembly has expressly provided in Pennsylvania's very detailed and excellent, in my opinion, election code. The suit contends the ban on curing ballots has to be retained. Can't fix a ballot. Somebody's signature doesn't look right. If they don't have both envelopes, if the ballot's not dated, you can't do anything after that, absent a law that's been passed to address all of that, because every county has to apply these things uniformly. And it cites a Pennsylvania Supreme Court finding in Pennsylvania Democratic Party versus Bookvar that while the Pennsylvania Constitution does mandate elections be free and equal, and we're going to spend a little more time on that phrase, it leaves the task of effectuating that mandate to the legislature. So if the governor vetoes a legislative bill and it's unsolved, court has to step out. Now, the Democratic Party, Senate and congressional committees intervened 3 weeks ago to oppose the injunction that would prohibit county boards from being able to work with voters to cure mail ballots. And the Democratic brief cites the 223rd Circuit ruling, saying since the Pennsylvania Election Code doesn't address cure issues one way or the other, local boards can do what they want, and that does not violate the Equal Protection Clause of the Constitution. It argues the Republican brief misrepresented the Supreme Court's ruling, which didn't take a position on whether county boards could implement cure procedures on their own one way or the other in absence of a state law specifically governing the issue. The Democratic Party arguments in this RNC versus Chapman case, which is pending, once again raise the questions of whether the state legislature is the sole body to determine how elections are run, or whether courts and other bodies like local election boards have rights to make decisions over election processes in accord with Pennsylvania's constitution and election laws. So as Governor Corbett raised earlier, and to me this is utterly fascinating as an outsider of Pennsylvania, does the Pennsylvania Constitution have additional rights it grants the people, the citizens of Pennsylvania, which transcend the basic provision in the federal Constitution giving state legislatures this right over time, place, and end. So now we're going to dive in to the Pennsylvania Constitution. Article 1, Pennsylvania Constitution, Declaration of Rights. All powers inherent in the people. All free governments are founded on their authority, instituted for their peace, safety, and happiness. Very broad, big idea. This goes back to this goes back to the 18th century. It's remarkable. Article 1, Section 5 of Pennsylvania Constitution election states, elections shall be free and equal. No power shall at any time interfere to prevent the free exercise of the right of suffrage. There's all kinds of implications of this language. We'll get into some of them over the course of this seminar. What's interesting about this is there's no equivalent provision that is this specific in federal law, in the federal Constitution. This is Pennsylvania 200 years ago already going above and beyond. It then reserves fundamental rights to the people. It makes the Pennsylvania Constitution special, which raises the question, who gets to decide this provision? Is this provision just a nugatory surplusage? Who gets to decide what it means and how it applies? Now, what's interesting is this has been used and applied in a few cases. And in Article 2, Section 17 of the Pennsylvania Constitution, there's actually something about reapportionment, which goes to reapportionment for state legislative houses, not federal. And it says that when you get into a reapportionment and redistricting, you have principles that you apply: population equality, contiguity, compactness, absence of splits within municipalities. And those principles, all arising out of free and equal, have been applied by the Pennsylvania Supreme Court to federal redistricting. In other words, the Pennsylvania Supreme Court has already said when it comes to thinking about gerrymanders, we're going to take these principles out of what free and equal means, and we're going to apply them for reapportionment decisions. So we have a state high court making decisions affecting federal elections and applying laws from Pennsylvania's Constitution to these federal offices. So this gets to the question of whether the US Constitution giving the state legislature the right to select time, place, and manner overrules the state constitution, which otherwise governs the authorities of all elements of state governments, as you articulated, Governor Corbett, executive, legislative, judicial. It's a very interesting constellation of competing texts and how you work it all through in a way that makes sense for everybody. We then get into some of the case law arising in Pennsylvania. Elections are free and equal within the meaning of the Constitution when they're public and open to all qualified electors alike, every qualified voter. When every voter has the same right as every other voter. When each voter under the law has the right to cast his ballot and have it honestly counted. When the regulation of that right doesn't deny the right or make it so difficult as to amount to a denial, and when no constitutional right is subverted or denied. That case is from 100 years ago, more than 100 years ago, from the Pennsylvania Supreme Court, interpreting what free and equal elections in Pennsylvania means. And then 100 years later, we have Justice Todd, League of Women Voters of Pennsylvania versus Commonwealth, saying, it's a core principle of our Republican form of government that the voters choose their representatives, not the other way around. That, by the way, is the core principle, literally the core principle of the organization I'm involved with, Keep Our Republic. That's the sentence that informs every part of our work. And that's right there, taken by Justice Todd in interpreting the Pennsylvania Constitution. So we have Republican and Democratic filings in RNC versus Chapman, providing opposing views of the meaning of free and equal, and the extent to which the courts and election boards have the right to decide versus the state legislature on its own. So this has become, unfortunately, and it's very unfortunate, and to a considerable extent, a partisan struggle. It's largely been waged over gerrymandering, who gets to decide. But it's now broadening to go beyond gerrymandering to deal with county election boards' rights and the degree to which they have the right at this local level to deal with things like vote curing. And we're seeing this play out in purple states or swing states all over the country: Arizona, Georgia, Michigan, Pennsylvania, and Wisconsin. And I'm focusing on those because in those cases we have Republican-controlled legislatures seeking to limit administrative and state judicial authority on interpreting laws, and Democratic Party governors, Secretary of States, or political committees trying to maintain those roles beyond the state legislatures. This brings us right back to this core question. What is the special role and how big is it of state legislatures to override other legal authorities like state constitutions, state statutes, judicial review? And when it comes to presidential elections, even federal law, like the Electoral Count Act. We don't know the answer to this question all the way up to the Supreme Court right now. We truly do not. It's absolutely in contention. So let's look again at case language, because the case language informs us. The Pennsylvania Supreme Court in 2020, unilaterally, on its own, not asking the legislature's permission, extended the deadline for absentee ballots to reach election offices. And at that time, 3 Supreme Court justices said, let's segregate those ballots so they can be disqualified, because we could ultimately decide that was illegal. And that's Republican Party of Pennsylvania versus Bookvar. In the end, the Supreme Court didn't take that up, but some version of the idea in back of that is supported by at least Justices Alito, Gorsuch, Thomas, and Kavanaugh, as reflected in dissenting opinions that include the following statement made by Justices Thomas and Alito. And this is expressly made by Alito, joined by Thomas. If the language of elections clause is to be taken seriously, there has to be a limit on the authority of state courts to countermand actions taken by state legislatures when they're prescribing rules for the conduct of federal elections. All of this says, wow, look at how central Pennsylvania is to this national discussion. And these cases don't involve New York or Massachusetts or California or Florida. It's Pennsylvania, Pennsylvania, Pennsylvania. So this takes us back into how far is this going to go and how far is this going to go in particular for 2024, which is really the next time this is going to deeply play out. Does the language in the Constitution mean the state legislature decides alone the question of who's won a federal election, regardless of what's in the state constitution or state law, or only decides on the manner in which the decision is made? Can it be made at any time, like after an election, or only under regular legislative order through normal lawmaking processes involving a signature by the governor and oversight by state courts? There are proponents of the hardest version of this theory, which contend the current legislature is the sole decider. Their power is plenary, and can be exercised at any time, even in theory after election day. And this is what was going on in 2020, when in December 2020, there were these actions being taken in an effort to get state legislatures all over the country to reconvene and issue their own certificates. And this term plenary comes from this 1882 case of McPherson v. Blacker, which was cited in 2000 by Justice Rehnquist, joined by Justice Scalia and Thomas, which emphasized the authority reposed in state legislature to appoint electors. Now, McPherson addressed this issue we raised earlier, district versus statewide choosing of electors. And it also applied to elections that hadn't taken place yet, not ex post facto. But this word plenary suggests any time that power is permanent and comprehensive. Now, under Marbury versus Madison, which is kind of the foundation of how we think about the role of courts in the United States, when Congress enacts a constitutional law, the law may not be enforced. We saw this play out very recently in New York State's gun law, the new gun law just being overturned by a federal judge. The ISL theory would flip this principle for state legislators, making actions of the state legislature over federal elections and presidential electors judicially unreviewable, in part, or maybe entirely. Now, Pennsylvania election laws have really detailed procedures for how local election boards are supposed to count and to calculate the results. I've got an example before section 1404, but you can go to the section 1403, section 1405, and a lot, and the whole rest of it. It's so detailed on how they go about counting at the local level. There's an awful lot of precision there. County boards have some discretion, but an awful lot of it's really been worked through by Pennsylvania over a very long time. Here, the idea would be, regardless of any of that, the state legislators would get to decide when it comes to electors. Now, we then want to throw in the X factor. So what's the X factor? When bad things happen to good commonwealths. Pennsylvania has experienced events in the past that could have really messed up past elections. Hurricane Sandy in mid-October 2012, which at one point could have prevented people from voting on election day. Cyber attacks on public infrastructure, like Philadelphia's mass transit agency, Pittsburgh TV station, WPXI, Pennsylvania's state Senate Democrats, Allegheny County District Attorney's Office, they've all been hacked and had to pay hackers a lot of money. There have been cyber attacks on them. We've seen street protests, disruptions, anarchists, vigilantes, from the left to the right. Any of those could disrupt a future election. You could have efforts to shut down access to public spaces when the truckers were protesting COVID restrictions. I'm thinking to myself, what happens if truckers decide to occupy Harrisburg at a time that electors are supposed to meet to choose the presidential electors? Who decides what happens when elections are disrupted? Either the popular election or the voting by electors on the prescribed date under the Constitution and the Electoral Count Act. This is the failed election problem, which you just throw in to everything else we've just talked about. What we've seen in terms of precedent, and this has mostly been in connection with disruptions of primaries, is you can have it make a situation where it really is impossible to vote. We've only had one federal contest where this has happened, and it was in Guam, the Mariana Islands, of all places, at 10 days before election day, and the governor issued an executive order postponing the general election and early voting. Otherwise, it's happened in primaries, but that included the primary in New York that was actually scheduled to take place September 11, 2001. Governors decided in every one of those cases, we're going to postpone the election, do it as quickly as we can, a week or 2 weeks later. It was 2 weeks after September 11th. And the state legislature said, yeah, that's a real bad disaster here. We're not going to interfere. But what happens if there's a disagreement between the governor and the state legislatures? That's not worked out. Now, the Pennsylvania Code has got very specific provisions that addresses this. And it basically says that the Secretary of the State gets the returns, lays them before the governor. and then the governor passes on the Secretary of State's computation and does the certificate and sends it up. But under the independent state legislature theory, the state legislature could say, hey, we've had this hurricane, we've had this cyber attack, we've had fraud, we've had protests, we've had variation in how things have been counted. The election's no good. We understand what the Secretary of State says. We understand what the governor says, but the election's no good. And we're going to issue our own certificate. Now, federal law covers this risky situation. It says whenever any state has held an election and has failed to make a choice, the electors can be appointed on a subsequent day in such manner as the legislature of such state may direct. So you have the risk here of a bad faith rogue legislature appointing its own electors on the grounds of a failed election. And could they ignore the popular vote in such a case? Maybe. With what results? Maybe.
Can I interrupt 1 minute?
Absolutely.
The city here is governor. I go back and look at this, and this is primarily a ministerial act on the part of the governor. The
Yes, sir.
Secretary of the Commonwealth has put together all this information, brings it over to the governor. The governor's not going to, I don't believe any other governors can go back and look at each individual county and say, are you sure this is right? You rely upon the delegation of the duty to the Secretary of State in that regard. And then he certifies it under the law. Is there, I've not seen, maybe we're going to get to it, anywhere that gives the legislature the authority, either in Pennsylvania law or in federal law, to issue their own certificate.
Well, under McPherson v. Blacker, as interpreted by the Supreme Court in 2000, in that opinion I cited a little earlier, there's some language which talks about how plenary it is. And that word plenary means complete, comprehensive. So what happens if they choose to do it? That's the issue here, because that was attempted in 2020. And I've just tried to describe some situations where we could have somebody say this election's failed.
Well, so could the governor veto that?
Absolutely. The governor could send his certificate,
yeah,
or her certificate, and the state legislature could send their certificate. And you then get into the competing certificate problem, which is that the Electoral Count Reform Act is trying to begin to fix. But one of the great fears is competing certificates. And I'm almost done with my presentation because we're getting there, because it's not just the problem of the rogue legislature. Unlike you, Governor Corbett, there could be a rogue governor. It could be Governor Weiner saying, I don't like this result. I'm going to decide I'm issuing the certificate because I'm unhappy with everything that's been produced. I don't trust any of it. I'm going to declare that it's no good. I'm going to send that certificate in. And then the courts go on and they might say, rogue governor, we don't accept it. But yeah, in theory, you could have it go either way. Rogue governor, rogue legislature. I'm going to get into the rogue governor right now, and then we'll conclude and hopefully have a lively discussion with my presentation part done. So the Electoral Count Reform Act, which, as I mentioned, it's amazingly supported by minority leader and the majority leader of the Senate, could well get enacted before the end of this year. Is intended to require the states to identify a single official like a governor or secretary of state to carry out this federal law duty to issue and transmit the certificate of ascertainment. And it would prohibit the official from certifying that the wrong candidates prevailed, since the outcome would not be consistent with state election law in place on the date of the election. This is to counter the risk that a rogue governor working with a Speaker of the House of the same party might certify a popular vote loser as a winner, and that's the scenario that they're worried about. And it would also place these decisions under expedited judicial review, first to the state courts, so that all state law, state constitution is incorporated, and then to the federal judicial review to ensure compliance with the law. All law is in place where there's compliance with a law that had been in place at the time of the election. So this says whatever the law was that was in place at the time of the election, that's the law we're going to apply. But I mentioned
You can't change the rules after the election.
That's right. It would seem to be a basic principle of due process and equal protection to me. but I'm not a Supreme Court justice. I've never been a judge at all. So I don't get to decide. I just get to apply what I think is common sense. So the risk remains, with or without the adoption of this new Electoral Count Reform Act. What happens if the Supreme Court adopts independent state legislature theory and finds provisions of the existing Electoral Count Act or the new Electoral Count Act Reform Act to unconstitutionally limit the power of the state legislatures? Don't know how far they're going to go. That's why Moore v. Harper is so interesting, even though it's in the context of redistricting, not the electoral count. Now, the thing that I worry about, and I really do worry about it, and I think we should all be thinking about, is if you had dual certificates submitted by the states, you could have partisan disputes in Congress under the 12th Amendment and send the presidential vote to the US House, voting state by state, each state receiving one vote. Utah receiving one vote, California receiving one vote, Hawaii receiving one vote, Florida receiving one vote. District of Columbia might get to vote actually in that situation. You can imagine what might happen amongst the citizens of the country in such a situation. I mean, we're still dealing with the consequences of the insurrection. I worry about civil unrest. You then get into complex issues involving the use of emergency powers at the local level. Governors would want to stop riots, blockades, and demonstrations, but you then get the president with his Insurrection Act authority. So you get into competing authorities on emergency powers, control of the National Guard, who's calling out what when, and the question then of activity of militias. It gets to be very scary very quickly. Pennsylvania's got 19 electors and a closely divided electorate. So if you got into this kind of a situation of dual certificates in Pennsylvania, it could make the whole country very unstable. And that affects economy, business climate, public safety, all kinds of things. So I worry about this scenario a lot. Public confidence remains an essential element to protect our democracy. So I'm asking myself what Pennsylvania can do to fulfill the promise of its constitution, that elections remain free and remain equal. Over to you, Professor Huhn.
Hi, everybody. Thank you, Jonathan. What a wonderful presentation, deep, meaningful, detailed, so detailed, in fact, that I'm sure we're going to have hours and hours and hours of discussion just to clarify everything.
You could spend, honestly, you could spend a whole law school class on almost any one of the slides in that presentation. There's so much to think about it in all of us.
Well, Chief Justice Saylor and I actually conducted such a class yesterday on this subject, and we had Professor Williams from Rutgers in as well, zooming in, and it was a wonderful discussion. Justice Saylor, we haven't heard from you yet. The obvious questions that we can ask at this point, having a former governor, having a former Chief Justice in this discussion is, do you agree? Do you agree that the state legislature is granted the power in the US Constitution to act independently of the state constitution, independently of state courts, independently of the state governor, independently of the veto power, and as Jonathan laid out, independently of election boards and the Secretary of State's office and all those regulations as well? What is your thought about that? And I imagine your thoughts on the significance and the role of state constitutions in this discussion as well.
Thank you, Professor. Yeah, I think for purposes of our topic today, and considering as we are this doctrine, but I prefer to call it a unrationalized theory at this point. You go back, really, as you must, to the founding, and you consider what the men, and it was a group of men that wrote the Constitution, might have believed about the word legislature. And I think it's reasonably clear, although, as Jonathan said, you can debate most points, but that the public, that there was a clear and accepted meaning of the word legislature. And I think a state's legislature was not just an entity created to represent the people. It was an entity created and constrained by a state constitution. So I think a state legislature is nothing more than a creature of that state's organic document, subject to all the provisions within that document. And those state constitutions, many of the original 13 states, preceded the national constitution of 1789. So if you approach it from that viewpoint, state constitutions do many things. They set up the form of government, the frame of government. They protect rights and liberties. They do things that the federal constitution doesn't do in the areas of education, elections, voting, taxation. But at base, the legislature of a state, including Pennsylvania, has no existence separate and apart from the constitution of that state.
Thank you.
And so, yes, I think, Professor, the legislatures of the states, Pennsylvania included, are constrained by the provisions of that organic document. And that leads to the role of judicial review, well accepted again before the founding, well accepted before Marbury versus Madison, where state courts would set aside actions of their legislature as violative of that state constitution.
Governor Corbett, can the state legislature act independently of the governors? Do governors retain their right?
I think
veto?
the only way that you could say they act independently on any law that they passed is if the governor vetoes the legislation. And I think any legislation they pass has to go to the governor. And if he vetoes that legislation, if they override it, that's not independent. That's part of our process.
But they would have to override the veto.
They'd have to override the veto.
Would that apply as well to any legislation they might adopt? For example, if they adopted legislation that said there's no longer going to be a presidential election in Pennsylvania, there is going to be the electors from now on will be selected by the state legislature. Would that legislation be subject to a governor's veto in light of the language in Article 1?
I don't think they could, because if you go back to the Pennsylvania Constitution guaranteeing everybody the right to vote, equality of voting, it would apply to voting for president also. I don't think they can deny the people the right to vote for the chief executive of the United States.
Because
Professor Huhn, you and I know this independent state legislative theory covers potentially the three areas that Jonathan outlined. So it has potential ramifications beyond reapportionment. As he pointed out ably, it governs the conduct of elections within that state, both state elections and federal elections for Congress and for Senate. And then, of course, it has some potential resonance on the selection, or more appropriately, contests over presidential electors. So for purposes of the complete constitutional analysis, in addition to having implanted within Pennsylvania's constitution a free and fair elections clause, which incidentally, and that was placed in our original Constitution of 1776, but the same can be said for North Carolina. They have a free and fair elections clause, which is at issue in Moore versus Harper. And that found its way into the North Carolina Constitution of 1776. So they've been around for hundreds of years. But there are other provisions in the state constitution pertaining to judicial authority. For example, in our Constitution in Pennsylvania, there's a provision that first came in Pennsylvania, like a lot of states, has several iterations of its constitution, unlike the national constitution. State constitutions are more amenable, easier to call conventions from time to time, and that's been done in Pennsylvania 5 times. Although you can also amend it by a vote of the electorate if there's a resolution passed in 2 consecutive sessions by both houses of the legislature. But for example, in Article 7, Section 13, contested elections, our Constitution provides that the trial and determination of contested elections of electors of president and vice president and some other officers shall be by the courts of law. So there's a specific constitutional assignment in Pennsylvania's Constitution that gives competence, authority to the Pennsylvania courts to adjudicate contested elections of presidential and vice presidential electors. So there's different provisions in our own Constitution, as Jonathan pointed out, that confer power on the judiciary in Pennsylvania.
Now, I have 2 objections to that reasoning. You know that I don't support the independent state legislature theory, but let me do my best to present arguments in its support. One is the Constitution of the United States is the supreme law of the land, and it overrides, conflicting provisions in state constitutions, state laws, and in the interpretation of the U.S. Constitution, the U.S. Supreme Court has the last word. And does that not override everything in state constitutions, state laws, state regulations? To the contrary.
I would say the answer to that is absolutely. So if you would get a determination in the United States Supreme Court that the independent state legislature doctrine was prevailing federal constitutional law, I think that would displace state Supreme Courts, even acting by reference to their own organic document, from being involved in congressional reapportionment and being involved in the conduct of elections, federal elections in their own states. So I believe that's the ultimate consequence of a determination adopting this theory, that it would displace state constitutions and state courts from any role in congressional reapportionment or the conduct of elections. And that's why I think we've all talked about the Conference of Chief Justices has filed an amicus brief, a very good amicus brief in Moore versus Harper. They don't file a lot of briefs, and I was a member of the amicus review committee for 7 years when I was the Chief Justice. But they do on important cases, when there's a consensus of the Chief Justices, they will file an amicus brief, as they've done in Moore versus Harper. And as often is the case, they style it in support of neither party. But they make these central points to the Supreme Court as amicus on behalf of the state interests. And they say several things. The Elections Clause does not prohibit state courts from reviewing state laws regulating congressional elections. Subpoint. It does not displace state constitutional rules governing state regulations of federal elections, and it does not deprive, contrary to the argument, state legislatures of their authority to provide for state court judicial review of congressional election regimes as part of their prescribed time, place, and manner. What they end as they must with this petition. Any federal court review of state court decisions interpreting state laws governing federal elections must be tightly circumscribed and apply clear limits. So if they're going to go in this direction, they're saying you must be deferential. You must come up with a fairly tight and clear test that's understandable and it provides a clear and workable standard.
How many of our state Supreme Court justices around the country have joined this brief?
It's not a question. The way it works, Professor Huhn, when the conference votes to file the amicus brief, I've never seen I guess you could lodge a dissent in some form, but it's determined by a majority vote of the conference that brief is proffered. And my guess would be, not having been privy to those conversations and not having taken any kind of a survey, and we have, several hundred justices or judges on our 50 state Supreme Courts. And I suppose individually, their thoughts might vary depending on their, not their politics so much as their ideology, their view of the interplay between the state and federal constitutions. But it would very much surprise me if there were not a strong majority of state Supreme Court justices that would be of the view that it would be a extremely significant and detrimental decision to displace state courts and state constitutions from a role in the conduct of elections within their own states.
Thank you. A question that arises throughout this is whether or not the right to vote in any context, but including the right to vote for Congress and the right to vote for president, whether that's a fundamental right or whether that is a matter of legislative grace. Is it something that's inherent in every American citizen, or is it merely something that is granted to us by the state legislature? I wondered what you think. Any of you?
If I understand, and I was looking at something on the screen that what we're looking at on the screen. Where is the right to vote established? To me, both in Pennsylvania and in the federal government in the US, it's inherent that we have a right to vote. It can be limited in time and scope to a certain extent by legislation. But I think the right to vote and participate in your government is inherent in the Constitution, both constitutions.
Do you agree, Jonathan?
I don't know how we could have a country in which people couldn't vote for for officials all the way up to the president. It's contrary to everything that's inside our heads about what it is to be a nation, a people, and a country. So this raises some pretty fundamental questions, but it's also absolutely clear to me that in theory, a state legislature could, prior to an election, say, we're going to decide from now on, we're going to take back the right to vote for president. It's going to be decided by the state legislatures who are elected by the people. And that could be accepted, signed by a governor, and become state law. Now, in that situation, there might be contrary provisions in the state constitution, which would then say even when the governor and the state legislature have gotten together to take away that right and go back to the earlier situation in which the state legislature picks the presidential electors, we're not going to accept that. And that would be interesting. That would be a situation in which the courts might apply bigger provisions of the state constitution. But my view is that it only makes sense that that could take place within the confines, as Justice Saylor has described earlier, and Governor Corbett, of the Constitution and laws that already exist. In other words, the state legislature couldn't do it on its own. It would have to be a law adopted in the ordinary course and subjected to the test of existing state law, including the existing state constitution. But I believe in theory, in some states that don't have the constitution that Pennsylvania has, a state legislature could take back the right to vote for president from the people and have it done by the state legislature only. I think that any state legislature that did that would find the voters would choose other legislatures pretty darn quick to restore their right to vote for president, because I think it's so embedded in the values of our country and in what people believe is the right to them, that to take it away is impossible in practice, politically, even where it might be possible legally.
Professor, could I make one other point since you've raised the supremacy clause? And maybe I'll tie it in eventually, if we have time, to a passage in the Rucho decision of the Supreme Court, where I can start there. But why don't I start there? I thought it was kind of interesting. And that's the case, of course, where after struggling mightily for 20 some years, the United States Supreme Court said, we can't come up with a manageable standard to assess or adjudicate this notion of political gerrymandering. And so we're done. It's no longer justiciable in the federal courts, a claim that a congressional reapportionment scheme is unconstitutional because it's partisan gerrymandering. But interestingly, the Chief Justice who wrote the opinion in that case said, our conclusion does not condone excessive partisan gerrymandering, nor does our conclusion condemn complaints about districting to echo into a void. And then he gives 3 examples as to what can be done. So he's saying that, there's pretty fair consensus that this isn't good. The Supreme Court is walking away from it because we can't discern a manageable standard. But don't worry, the states will take care of it. And the first example he gives, Florida's already done that, and they've done that under a constitutional amendment, their Fair Election Districts Clause, and that's fine. I don't know why I didn't mention legal women voters, but maybe some clerk missed that. That predated Rucho, I think. And then he said other states have assigned it this function to independent commissions. And he gives some examples. And then he says, finally, Congress can act. So there are remedies, but it's interesting because he says that there's a very real role for states acting pursuant to their state constitutions to adjudicate claims of partisan gerrymandering. Now I'll come back to the point about Congress, but the interesting thing to me was that passage was joined in full by Justice Thomas, by Justice Gorsuch, by Justice Alito, by Justice Kavanaugh. Nobody said, wait, what are you saying here? You can say sometimes something by way of concurrence. I join in full the opinion that declares partisan gerrymandering to be non-justiciable for federal purposes, but I have a real problem, Chief Justice, when you're starting to invite the states in, because there's this other theory floating around that would prohibit that. But it is what it is, and maybe if someone were to ask them, not that they have to answer, they say, "Oh, I didn't exactly focus on that," or "That's dicta, and I didn't pay much attention to it." But it's kind of ironic that within the year or two, you have 4 justices, as you can see in the dissent from the denial of a stay in Moore versus Harper, that now present this theory front and center. But it's incompatible with Rucho. But the final point I'll make is there is a possibility under Article 1, Section 2, Clause 1 for congressional involvement. And you know, back in the 1800s, there were several acts of Congress, like the Single District Act. There was something about equality, and those were eventually displaced by the Reapportionment Act in the 1800s. But there is, but again, politically, would it ever be possible? You're talking about the Electoral Count Act. Can Congress come together? Could they ever come together on a federal regime for dealing with congressional reapportionment? But if they could, in that unlikely event, that would displace state courts and state constitutions, because that would be a federal statute tied to a specific power grant in the Constitution. Namely, Congress may at any time by law make or alter such regulations. And so an act of Congress would also preempt, or would preempt, state courts and state constitutions, actually state legislature. So those are a few points.
I have a very general question about sovereignty in connection with this, and that is, does the U.S. Constitution and, behind that, the people of the United States have the authority to grant powers to state legislatures or to limit the powers of state legislatures? I know that the U.S. Constitution can establish fundamental rights that the laws of every state have to respect, and no state can interfere with the fundamental rights of American citizens. That kind of law is supreme. But what about the powers of state institutions? I know that the U.S. Constitution establishes the various instruments of power in the federal government, institutions and officials. But does the U.S. Constitution have the power to set up official institutions in the states and grant those powers and limit those powers? I'd be very curious about whether the entire theory of the independent state legislature doctrine rests upon solid ground in sense of the authority of the people who write our basic instrument. Do the people of the United States have the power to grant and withhold power to the state legislatures, or is that up to the people of the state of Pennsylvania?
I would, personally, I would think and hope the answer to your question is no.
That the U.S. government can't alter the powers of the state legislature.
Not the organic, but of course you're subject always to federal preemption, and there are areas. But you were talking about changing the structure of a state constitution, and portions of a state constitution can be stricken by a ruling of the United States Supreme Court by reference to a provision of the U.S. Constitution, and they would be violative. A particular provision of a state constitution could be held to be violative of a provision of the United States Constitution. But I would certainly hope that the reach of the federal government wouldn't include altering the form of government or the constitutional structure in a sovereign state. And that to me was always one of the great compromises of the Constitutional Convention. I think there was a realization at some point over the disagreement of many that only a government framed in a federalist mode would have a chance of ratification. And therefore, the document that emerged from that convention created a system of dual sovereigns, each supreme in its own sphere, yet interlocking to form what James Madison in Federalist 51 called the Compound Republic of America, or the Federal Republic of the United States. So I think there's a very real historic and constitutionally based notion that we are a system of dual sovereignty.
Isn't that what the 10th Amendment provided us? If I remember my amendments correctly. I don't have the Constitution here in front of me. It's over in my briefcase. But
I have it here in front of me, and
it's the 10th,
but
right?
it seems to me that's what it said, but I'm not sure the United States Supreme Court's ever agreed.
Jonathan, what do you think of that larger question of the authority of the people of different jurisdictions to set up powers? It's the difference between rights and powers. The fundamental rights are uniform throughout the United States, and the Supreme Court certainly has the power to declare what those are. But the powers of state institutions, does the Supreme Court and the US Constitution have to take those institutions as they are in the states, or can they alter those powers?
There is very limited language in the Constitution, which is, of course, the underlying instrument. The US Supreme Court only has its authority within the context, right, of the federal Constitution. That's where it begins, not someplace above that. It's not some divine right. It's a right based on the Constitution itself. And there are very few provisions that really govern what state bodies may and may not do. And that's what makes all of this so provocative, is that we have these two provisions in the Constitution, which confer particular rights on state legislatures. And they don't define what a state legislature is. I think that both Governor Corbett and Justice Saylor have, and you, all three of you have articulated in the course of this, elements of why we all believe the state legislature exists under state law and state constitution, and that there should be a very limited authority of the Supreme Court to define what that is outside of what they say it is. And it probably still exists because they do have to, in the end, interpret the law of the land as a whole in a national unifying way. When it comes to president, that's a national, that is a national authority. The president of the executive branch, big job, covers all of us. And so to have a uniform approach to how that's selected, it seems to me certainly is within their authority. But they should do as little damage with that as possible, meaning there ought to be as much respect for all other laws and constitutions and equities that go into it, including the basic principles of due process and equal protection, which of course were enacted later than the original Constitution, and therefore modify it or amplify it and further shape it and need to be incorporated into an understanding of what's meant by the state legislature shall choose. So this whole notion of the state legislature's power being plenary when it comes to electors and presidential choice, I personally believe should be interpreted to be modified by both due process and equal protection from the post-Civil War amendments and the 14th Amendment in particular, and the other elements of 13 and 15, which also play out here. And the if you interpret that therefore organically, and some of what's in Bush v. Gore comes out of due process and equal protection analysis. The goal here should be to provide for uniformity without very, very, very tight direction on process, because that's always been given to the states to do under their state laws. And so this dual sovereignty that Justice Saylor just described tends to work really very well when people are operating to create a neutral operating system for the whole country. I'm going to shift metaphors for a moment. To the extent you have operating systems, as an operating system like in a computer, that's fair, in which the processes are designed to promote fairness, that does not take into account advantages for one party or the other that may be transient or long-term, but which is designed to try and be inclusive and operate neutrally as to person, as to party in connection with voting. That's a civic good. That's going to be good for absolutely everybody in the long run because it's treating every voter fairly in every state and giving weight to each vote and the autonomy to each person. That's a universal value. And that universal value is an important value of keeping us all together as one country. And the risk of independent state legislature theory is the degree to which it begins to give power to people who've been elected to change the operating system, to be able to select what the outcomes are going to be through tilting the elections, either before or after, to their particular preferred results. That's the risk. And the risk in connection with failed elections, which I talked about in my presentation, is that someone takes advantage of a situation in which there's a problem, and instead of applying neutral principles, tries to change results to get a particular candidate in. And the whole riskiness and danger of Bush v. Gore in 2000 was the perception amongst some that the Supreme Court intervened in a way to tilt the election to a particular outcome, which is why the justices themselves say, oh, by the way, don't rely on this precedent for anything else in this case. This is a one-off. We don't want this overly applied, because they themselves recognize that there's always a risk of voters feeling that elections are being tilted by judges. And that would be an awful outcome if we felt that either judges or legislatures were tilting results one way or another. You want in the end the voters to say, yes, these elections are good. I don't like or I love, whichever it happens to be, the result. But the processes were neutral, fair, and impartial. And that's the public good that we should be aiming for. And the reason why I find Pennsylvania so interesting is because you have applied state law to use principles of neutrality and impartiality in an effort to increase neutrality and impartiality so that voters can trust the system and there's a sense of basic fairness. That's how I perceive what's the struggle in Pennsylvania. And I would like to see those principles win out on a national basis, not to secure victories by Democrats, because while I am a D, my view of the Constitution and of the country, forget the Constitution from it, let's talk about the country, is that voter trust and belief in the system depends on people feeling that it's impartial. And much of my work has been done overseas. My last job in the federal government was special envoy for Libya, which is a country which is coming apart over legitimacy, and individual politicians trying to maximize their advantage to gain more power and being unwilling to accept neutral principles and having the whole country fall apart. And my whole goal as a special envoy was to get a temporary government in place that could operate just long enough to allow elections to take place so the people of Libya could select their next president rather than just a parliament for a prime minister in this case, because the lack of a president elected by the people was impairing the legitimacy of institutions across the board. So I've seen this play out in other countries. And my fear for the United States is that we wind up with a system in which there's no longer acceptance and trust that the operating system is fair and neutral and being applied so that the people decide. And my civic organization, Keep Our Republic, that's our goal. Increase public trust, find ways of supporting neutral principles, prevent anyone from tinkering with the operating system to favor their side, which is why I was so encouraged by Senator McConnell and Senator Schumer supporting the same reforms at this time in 2022 for the selection of a president. That is a remarkably important civic achievement if they can do that. I don't know what's going to happen next, but it's a very big deal to me because it transcends partisanship. And that is so important at this time. I apologize for my long-winded answer, but that's what stimulated. Thank you.
We have with us, of course, two individuals who stood for election statewide, who obviously are committed to democracy, and win or lose, you know, that's how we Americans try to conduct our business. That's the ideal. Governor Corbett, you mentioned one way of attacking the textual argument in this case, really a strictly textual argument, almost an ahistorical argument, be made on behalf of the independent state legislature theory. And you said that you focused on the word manner and suggested that perhaps the state legislature's power, even under this theory, is limited to manner.
I think it is limited to manner. You know, while we were talking here, I went back to the notes that you sent out to us, and I made a circle around it. It's, you know, not who you're going to vote for, what the results are going to be, but it's the manner. And they are allowed to do that. But I want to go back to what Jonathan was saying. Even about 2 minutes before you started saying it, Jonathan, I'm sitting here thinking, we're not talking about the 14th Amendment, which I think plays well into this whole issue of making sure that due process is out there. Especially if you do it ex post facto, due process has been violated, as far as I'm concerned. And that due process has to be conducted well and ahead. What is due process if you want to do it? You make changes either at Congress or in the legislature, and they've gone through their due process for making these changes. You know, there was a vote, the bill was passed, it went to the president, it went to the governor, it was signed by there. Anything after that fact, but the fact that we're even talking about this independent legislature, to me, is just difficult to accept that anybody's thinking along these lines, especially the commentary from some of the members of the Supreme Court, that there is a theory. There are theories for a lot of different things, but this is a basic, I think, in this country of how elections are to be conducted. The 14th Amendment specifically addressed to make sure that people got that right to vote. Remember, a lot of people post-Civil War were not getting their right to vote. The Crow laws came into existence. 14th Amendment, if you look at all of that and everything that's come in so many different ways, go back to the 14th Amendment. So any discussion of what's going on about an independent legislature, I think also needs a discussion that Jonathan just brought up about the whole 14th, 15th, and 16th Amendments as they apply post, you know, the Civil War, and why they came in. I think it was to prevent thoughts like this.
You mentioned earlier that the right to vote is inherent, that it's inherent in us. Again, taking a devil's advocate position, but one I think may have some merit. That wasn't necessarily the case at the beginning, was
Right.
it?
No.
The white men who held property had the right to rule, the right to vote, and the idea of the whole electoral college was that these are going to be the best people in society. People like us, you know, people who look like us, people who come from the same upper stratum of society, and they'll be the electors. The state legislature will pick them. We won't have the rabble, you know, electing the president. We don't trust them. They can elect the House of Representatives. They don't get to elect senators. They don't get to elect the president. That was the original. And now I know we've all changed. I know we don't believe it. And I believe that as fervently as you have stated it, that the right to vote is fundamental, that we're all equal, But, you know, could the Supreme Court say, well, you know, we'll Tom, you're deluding yourself, because when those words were written, giving the state legislature this power, they didn't believe that, and they thought the state legislature should be able to.
But we've addressed it since then through the Congress and through amendments that apply to the entire country, that basically says everybody does have a right to vote, including, oh, by the way, women who didn't have a right to vote until what, 1918, 1920?
20, yeah.
Okay, so, you know, and for all the ladies out there, I didn't forget about you. But, you know, I think what the country has done, Congress has done through passing legislation, and when there are constitutional amendments, they are voted upon by the legislatures of the states, as I recall my civics. So there's an agreement, and now that agreement has solidified in my mind that everybody, every citizen, not a non-citizen, every citizen has a right to vote.
Now, the US Supreme Court, well, at least Justice Alito, refers to a vague provision of the state constitution. I assume he's referring to the free and equal elections provision. Calls that a vague provision. And we know that this court, in their recent decisions, has adopted a textual method of interpretation, you know, a very semantic method of interpretation. And I detected, perhaps I'm reading it into it, but I detected some level of scorn in Justice Alito's opinion for vague provisions like free and equal. And of course, due process is a vague term. Equal protection is a vague term. And the more specific a term is, the easier it is, of course, the more appropriate it is to interpret it with a purely textual approach. Is this, am I?
Well, let me interpret it my way.
Go ahead, yeah, go ahead.
And, you know, that was written in the Pennsylvania Constitution, I forget, early, I wish Joe Mystic would chime in here. Early 1700s, we had it.
Predating the revolution, Tom? What Tom Saylor was that?
Those authors, I think, were being careful. They didn't know what they were creating. They didn't know where it was going. They were allowing for the document that they came up with to be reflected in the times. Like, I can't guarantee it. I doubt that they ever thought that women were going to have the right to vote. But they didn't prevent that from being created. The vagueness that you're talking about, I think, is more a descriptive vagueness. It's not the law. These are goals. This is what we're trying to achieve.
So we stand on their shoulders.
We have to. They're their foundation.
Try to see a little.
We've grown, and we've had interpretations by courts. Some you agree with, some you don't agree with. But that's why we have succeeded, I think, as a republic. You know, we're not a democracy. Everybody says we're a democracy. We're a democratic republic. The people get the right to vote for the leaders who are going to make the decisions, including, in some instances, justices in the various states and judges in the various states. But the process has been tested and tested. And the fact that we're going to, you know, we can look at, and this is great, you have a debate, is this theory legitimate? I don't believe the theory is legitimate. That's my opinion. You may agree with it. That's great. The Supreme Court's going to have a great opportunity here to either allow this to continue or to end it, nip it in the bud.
Professor Huhn, there may be some questions from the audience. I see some pop up, but you had suggested when we met preparatory to this, posed a question which we may or may not get to, but I'm going to raise it. And that's because one of the implications involves the Electoral College, and your query was, you know, is this something that makes sense, or is it time come and gone? For a lot of reasons, is archaic. but I speak only for myself. And I think the Electoral College, even though now it's not implemented the way it was used to be, but it's still the notion that a state votes by the number of representatives in Congress. I think it's ingenious, and I would be very disappointed if it would be abandoned for a national election as we have in Europe. This is just my personal view, but Professor Wexler, a very thoughtful professor that I had years ago in law school, wrote a seminal article called The Political Safeguards of Federalism, and he makes the case for the Electoral College. And it really forces, when you think about it, somebody that wants to be president of the United States to assemble a national consensus, a national coalition across the length and breadth of the country. And I think there's a lot in that. And you understand the reverse, I think, is a practical political matter, that probably the Democratic candidate for Congress would spend all his or her time on the West Coast or up in New England. I just think it's, as many things are that emanate from the founding, it was an ingenious system, and I hope we continue.
Can I jump in? Because I'm looking at some of the questions that we have from the audience,
Go right ahead.
and I'm going to combine two. First one is, what role do individual citizens, voters, play in maintaining our republic? And the second one, there was more explanation after that. And the second one, are today's voters educated as to what the ISL, just moved on me, what the ISL theory means in practical time? I don't think the vast populace today is educated enough in civics, political science, or whatever. And I think we're losing that in elementary school and grade school. People aren't being taught about the government and the three branches of government. So I think one of the things that people can do is get back to the basics and understand what's going on. This independent legislature theory, I think, is very esoteric. I understand why people may be taking a look at that. But I think that the best thing that individuals can do is go out and vote. They can go out and vote. One of the questions talks about the people who felt unable to do anything when they were watching what was happening going on in January the 6th. And I mean, I certainly understand that. And from my role as a former governor, former member of the National Guard, I'm sitting back going, was nobody prepared for this? This was almost inevitable. If they knew there were going to be thousands of people there, nobody at the district level, the District of Columbia level, or even the Capitol Police were prepared that what would happen if somebody came down here. And Jonathan, you correct me if I'm wrong, but I think Keep Our Republic, which I participate with you, one of the things we're trying to do is educate the people as to what the potentials are out there. And we need to be thinking about elections and threats to the stability of our government going from now forward. People never thought about this before, at least not since the Civil War. And even then, it was secession. The only attack that we saw in the beginning of the Civil War was on Fort Sumter. We don't want to see anything like that. I don't want to see anybody secede from this country. So I think it goes back to education is what we need to do, not just as law professors and people on here, but the media. And you're going to hear my gripe about this. I call this is very useful for good and bad. We need to get good information out there, truthful information out there, because Jonathan made one statement I agree with completely. The trust of the people of this country in the United States government, in the state government, in local government, in government in particular. I think if you took a poll on that right now, my guess it's well below 50%. And that can't be. I'm off my soapbox.
I mean, when you look at the work of what they're doing at state election, county election boards at the local level, year after year, over hundreds of years, they're gaining more knowledge on how you count votes and how you count votes fairly and what processes and procedures are needed. You get into Pennsylvania State Election Code, it is so long and so detailed and so deeply reassuring when you start reading it about the amount of process that's neutral processes. And you then look at what are the county election boards trying to do right now. They're trying to cure votes when votes come in that aren't exactly following procedure, so they can be fixed to fit the exact procedure. Not fixed as to who people vote for. That's not what they're trying to do. They're trying to make it possible for the vote to be counted by getting the signatures right, by getting the envelopes corrected, whatever. And that's what's happening at the county level. What's disturbing is that equal protection right now is being used as a club to say if you don't apply the processes exactly equally, all over a state in exactly the same way, which is prescribed by the state legislature, it's not fair. And that disables the county election boards from trying to adapt when there are gaps in the law. The Pennsylvania Supreme Court has properly said if there's a gap, you can go in to do the best you can while there's a gap. If there's a law that's passed in the ordinary course that specifies a procedure, you honor that. So at the margins, there's a very tricky interplay of all the different institutions to try and create a fair system. But the equal protection idea ought not to be used as a club to disable institutions that are trying to perfect the system. The goal should always be to find ways that promote the ability of voters to participate. And so we had a question about the role of the county boards of elections. It seems to me that their job is to administer the laws when the procedures are set down, to follow the procedures, and when there are gaps, to do the best that they can to fill the gaps. Like anybody else in government does, you're constantly being presented with difficult cases. My concern, again, is when you get into bad situations. I talked about hacking. I talked about civic unrest as being bad situations. The then grabbing of political power and authorities to act in bad faith as a risk. And the ultimate nightmare being dueling electors, dueling certificates, people being motivated on both sides of an election, a two-party system, both sides being each party, to come out and start protesting. You've got governors with the authorities to bring out the National Guard. You've got the presidential's authority to do it. It could be done by mayors at the local level, potentially. In that kind of situation, we're in a civic nightmare where the country's coming apart. And so the educating people and motivating people to get involved, to vote, and also to understand the system and to participate in it, including in the voting system, whether it's election monitors or election helpers, whatever the different roles are, and there are a variety of different roles, manning the local voting areas. It's all really important to get people into, so they feel a sense, this is my country, I'm participating in, and the system is a fair system, in which I'm a member as a citizen of a fundamentally fair system. And what was so disheartening about the insurrection and the efforts to build out alternative slates of electors to those who were certified by the governors was it providing fuel for the idea that our elections aren't fair. And once you get there, the United States can become Libya. And we don't want to be Libya, I can tell you. In Libya, there are local militias who enforce the law by their lights, and people pay them off. And so the local militias serve the people who pay them off and then become militias for hire. And that's the way security is done at the local level, which is destroying that country's ability to function as a country. I spent a lot of time on it over the past decade. And every time I look at it, I say, we don't want to go there. We want them to become more like us, not us to become more like them. And when you get into a situation where people can't accept the result of elections because they don't think they're fair, we become less like us and more like them. And them is not a good place to be.
Professor,
Please.
picking up on the broader point that the questioner raised and the point that Governor Corbett made and that Jonathan made, what can people do? I think there's a lot of people that decry what they call the loss of civic virtue. And that was something that really animated the founding. It was in the minds of the framers, minds of the people that ratified the convention. And, it's a concept that comes from the Greek philosophers, primarily Aristotle. But as I understand it, it means that you care at the end about the greater good. And, I think if we had more people that thought in those terms, you put aside parochial partisan interests. And that seems to me what always separated, as Jonathan said, the United States in our 240-year history from other countries. And particularly, it was an orderly transfer of power. Elections were contested. They were often contentious throughout our history. But when the election was over, we moved on as a country and looked forward and not backwards. And that, I think, is the probably a large measure of why we're sitting here today talking about some relatively obscure constitutional theory. But that, again, is just my view.
Can I bring up one more question that we're seeing on the screen? There's a couple other questions, but I see we're running out of time, but this is an interesting one. Where did it go? Somebody just bumped it. Okay. Does the independent state legislature have an important function in the event that the state legislature determines that evidence of fraud is discovered subsequent to the certification of the electoral voters? Now, my first question as the prosecutor is, what kind of evidence? How much evidence? I would say that there has been fraud in elections in this country and in this state probably since the late 1700s. So when you make it, when the question comes out like that, I think if somebody would discover somebody that was sitting, let's say in Russia, and controlled all of the voting machines and fixed it the way they wanted it, then you've got an issue that not just the independent legislature, any legislature is going to want to look at that, including the federal government. The likelihood of changing the outcome for no fraud is insignificant, but some evidence of. The question is, if you could prove it, what would you do? Would you vacate the entire election 2 years later? Because as you see, any investigation, it doesn't get done in 5 minutes, 10 days, or even 50 days. It's going to be a year or two. So as I see that, I think when you find evidence of fraud, you use it in the next election cycle as to how you fix that.
Yeah, there is a provision in the Electoral Count Act in federal law, which allows us, this is now not the Constitution, we're now down into federal statutes, which says in the event of a failed election, the state legislature gets to decide.
How do they define?
They don't. They don't. So this is the problem. So if the state legislature determines evidence of fraud is discovered, subsequent to certification, they could set up their own certificate. There's no doubt about it. They can do it. And that gets us into this very, very dangerous territory, because you would have to have really good evidence of the fraud, and the fraud would have to be sufficiently pervasive, in my view, to have affected a lot of votes, but differences over procedure, that's probably not fraud. That's differences over procedure. In the last election in 2020, we had megaphones saying there was fraud all over the place based on theories of interference by Venezuela, or was it interference by Italy, or was it interference by China? There were a variety of different theories over it, which were not fact-based. In fact, there was litigation now brought by a voting machine company, Dominion, against allegations that its computers were tainted, filled with facts that were not facts, and where a variety of people are settling in response to the litigation because the statements were not well-founded and were defamatory. But in practice, could a state legislature do this? I think they can under federal law, not just the Constitution here. I'm not talking about ISL. I'm actually talking about failed election theory, which is a different part of the Constitution we didn't talk about today. And they could do it, but then it would have to go through the ordinary course where I think, where then you could have a gubernatorial veto, and you'd be in the never land. Does the state court then decide whether it's constitutional or not? Under state law, probably. Does the federal courts then have the opportunity to review the state court? Absolutely. Could it go up to the Supreme Court? For sure. And we're in a whole mess of trouble at that point. So one of the goals should be to prevent that from happening. And that's why I get down to having such respect for what's going on at the county level with the election boards, and going down into the process, the procedure of all the checks and details of the processes. So you can't just shout fraud, failed election, but you actually have to have something that's grounded in fact. And that gets to this question of early voting and early counting, which we haven't talked about. From my perspective, in general, not speaking about Pennsylvania in particular, the longer the period of time that people have to vote ahead of election day, and the more time people have to count the votes as we get to election day, the better off civic confidence will be. Now, there's some negatives to it. If you were to publicly release it, you'd have a running total, and then people getting motivated, they get their parties involved to get more of this side, that side. I don't know that that's necessarily great. They have a public disclosure ahead of time in terms of public policy prescriptions. But the basic idea of lengthening the period of time for voting, I think is a good idea, because if you then have a crisis on election day, more people will already have voted and less risk of actually facing a situation of a failed election. So if you can do that while maintaining processes that reduce the risk of fraud, that potentially empowers voters to vote and reduces the risks of what happens if there's some IT shutdown, if there's some hack in some place involving a substantial number of voters that happens on election day. So there are things we can think about as a society, state by state and nationally, that might work to reduce risk. But the idea of all this being determined locally, I'm a huge believer in, because I trust the depth of the processes. There are so many of them at this point that the more you look, the more you say, these are pretty good. These are really developed over a long time. I respect these. I respect the people doing the work. These are impartial people. This is basically a fair system. But that fraud risk, the people alleging fraud is very dangerous. As it is dangerous in its way as the danger of the Russians or the Chinese or anybody else coming in and fixing the system, which you protect against by always maintaining written backup ballots, which is essential.
It is time for us to wrap up. Jonathan, that was a wonderful wrap up there, but we'll give you another chance as well. Each of the three of you take about a minute. We have to give our administrators time to finish up the administrative detail on this first, but just your very brief concluding thoughts. Tom Corbett, you want to go ahead?
Well, I think what we've set the stage is probably will for another COE down the road to expand upon what we were just talking about with Jonathan, but also with what is a failed election. I mean, is the allegation of fraud enough? To me, it's not. I think part of the problem with what occurred before December or January the 6th, the allegations that there were fraudulent ballots, boxes of fraudulent ballots, nothing ever came of that. That's what prosecutors, those of us who have done prosecution, we can't go to court and just say, well, we think they did something wrong. We have to have proof of it. Now, are there indications that afterwards maybe there was something wrong? Yeah. We could go in, how do we prevent fraud? And I took a position on that as governor and got lambasted. I'm not going to bring it up right now. I will with my colleagues at Duquesne University, who find it, making it impossible for people to vote. But how do you reduce fraud? I'll leave that as the question for the next seminar.
Justice Saylor.
Well, appreciate everyone listening in, because I do think it is obviously an important and timely topic. And we'll have an answer in due course, but it really could determine the balance of power between the national and the state governments in an extremely critical part or portion of our democracy. And that is a balance that's been maintained, as we've talked about many times, for 240 years. So it does implicate the role of the sovereign states acting under their constitutions in our federalist regime.
Thank you. Jonathan, last words.
Sure. The recent case brought by the RNC and the state Republican Party against the acting Secretary of State illustrates how important the independent state legislature theory has become, because it does purport, as the last questioner in our chat just raised, to limit the discretion of other parties to set rules when the state legislature has not acted. And so figuring out what exactly where the margins are, the borders are for everybody's authorities is going to be a very significant element of our legal system's protection of voting rights and voting authorities in the days to come. And we're focusing on the margins, but it goes all the way from the margins to the center. And the more educated people are, and the more people get involved in helping us think through these processes, the better off we'll be. Civic unrest could lead to economic meltdown. The two of them could lead to changes in who we are as a country. If Pennsylvania can get this right, as a state, given its extraordinary centrality in terms of its partisan neutrality, being so purple as it were, and given its state constitution, it can really help save the country. It can be a keystone to the protection of the democracy. So the more discussion and engagement there is in Pennsylvania on these issues, the happier I am. And I'm grateful to all of you.
Thank you so much, all three of you. Sam, back to you.
Thank you so much, gentlemen. I'm going to leave your pictures up for a minute here. We so appreciate the time and effort that you put into this presentation today. So many of you mentioned education as a key component, and I think that you did a fantastic job today of contributing to the education of all of us who had the pleasure of watching and listening to you. I'm going to deploy a final poll right now for our attendance, for our attendees, and then I will end the webinar. My presenters, you are welcome to turn your cameras off at this point, and please know how very, very grateful we are.
Good. How are you? I thought so.
Tom,
Hey,
your speaker's on. Just, I'm gonna end the webinar now, but I just wanted to let you know, I have a couple questions to answer here from people.